after the hour of 2. And again, we're honored to have a lot of great speakers, and I'll try and introduce those. But the first person, going to talk a little bit about the liability issues related to returning or transitioning back to the work site for with COVID-19 is James Westbury of GMA. Take it away, James.
Thanks, Dan. I appreciate the opportunity to talk to your participants today and participate in this panel. I want to spend some time talking to you about the kind of general liability risk that a city can have, city or county really, for returning to work for the COVID-19 epidemic. I'm going to focus primarily on liability to third parties. I will touch on employees briefly, but I'm going to really lean on Doug Dewar from Ellerby Thompson to deal with the kind of employment law issues that cities can have. I want to start by talking about a misconception about COVID-19 that's sort of out in the marketplace of ideas, and it's that we can stop the coronavirus. When this thing first came over here, the president said, it may not come here, and then he said we've got it under control, and then the Speaker of the House has faulted the president for not stopping the coronavirus, and both are wrong. This is not something you can stop. This is nature. This is biology. We've had pandemics through history. This is just the way God does it, and we're going to get through it eventually. It's not going to be fun, but we just got to manage it, but we cannot stop it. So let's talk about what we do know. We do know that the coronavirus occurs naturally. This is, for whatever reason, just something that nature does. We live in a global marketplace where people travel internationally and we trade internationally, and that's accelerated the spread. It's not that bad in most people who get it. It's a real disruption because you have to self-quarantine, and it just turns things upside down. But for a significant portion of the population, if you get it, the death rate is very high. Overall, it's probably between 1% and 2%, but in a certain population above 60 or the population that has other health issues, it's around 20%. So you have at-risk populations that are very significantly impacted. I read this morning in a publication that 40% of the deaths in the country at least are in the nursing home population, and they have been sheltered in place by definition. But having said all that, eventually it's going to run its course. And it can only run its course and be eradicated when there's herd immunity or a vaccine. Both of those are going to take some time. So what we've got to do is try to manage it. People are going to continue to be affected. People are going to be infected on city and county properties, and cities and counties at some point are going to be sued. So what we've got to do is try to slow the spread, minimize exposures on our properties. When there is infection, which is going to be inevitable, we've got to try to avoid liability. And then on the flip side, when we take measures to prevent the spread, that may lead to a different kind of liability, and we've got to manage that as well. So I want to take some time and talk about those issues with you today. There's two kinds of liability we're really going to have to deal with here. You've got liability to people who get sick and or die and or spread it to people who get sick and or die. And then you've got liability to people whose rights are impacted. And you've got to balance those two. It comes down to a policy judgment in most jurisdictions about, what's more important, protecting life and health or civil liberties. And there's a right balance, but it's a policy judgment that elected officials and city and county managers are going to have to make throughout the state. What I want to do is talk to you about the category of plaintiffs who our cities and counties could see, and talk about the exposures and the steps that can be taken to mitigate that risk in the litigation context. The first plaintiff we might see is a member of the general public. Let's say you have someone who says, you know, my kid got COVID-19 at the grocery store. The city should have, enacted an ordinance or sent the police out. The people were down at the store, not social distancing, and my kid got it, and I've got 3 weeks worth of medical bills, or my elderly mother got it, now she's dead, and they try to sue the city. There's some protections that are built into the ordinary legal fabric that you have. The one that comes to mind foremost is the public duty doctrine. In the police protection context, and what we're talking about is police powers. In the police protection context, there's no general duty that a city or county owes to provide police protection services absent a special relationship. That special relationship would not come into play in a situation like this. It's generally what lawyers would think of akin to the promissory estoppel doctrine, where somebody calls in, the jurisdiction says, don't do anything, we'll be right there, and then they don't show up, and as a result of that detrimental reliance, somebody gets hurt or killed. That's not what we're talking about. We're talking about the situation where the members of the public might have an expectation that a city or county will put measures in place just to generally protect everybody. That's not something you can maintain a civil action on in Georgia. Georgia has a very strong public duty doctrine, and that would be a defense and would probably lead to the dismissal of a lawsuit. The other thing we've got that's specific to this context is the executive orders that the governor has issued. All the executive orders have had this preemptive language that restricts city and county governments from adopting provisions that are more or less restrictive than the executive order. What that means is you couldn't do it if you wanted to. If you wanted to be more protective, you couldn't. All you can do is carry out the governor's executive order. So there's nothing you can do. If you don't have actions you can take, if you don't have a standard you can live up to, it's impossible for you to fail to perform that duty if you couldn't do it to begin with. So in my opinion, anyone who filed a lawsuit of this nature, and we do see claims that are specious and frivolous of this nature, but if one of those lawsuits is filed against a city or county, I feel like it would be resolved very early on a motion to dismiss. The second plaintiff you might see is your employee. If you have an employee who gets exposed to COVID-19 in the workplace, they might try to file a lawsuit against the city. That's not going to work because Georgia has a workers' compensation system that has an exclusive remedy bar. Now, let me take a side trip over here and tell you that COVID-19 claims are not compensable workers' compensation claims, but under Georgia law, a claim does not have to be compensable in order for the exclusive remedy to apply. If the injury happens in the course of employment and within the employee's duties, that is going to be something that's going to be subject to the exclusive remedy bar, and your employee cannot sue a public or private employer. That said, it's not compensable because it's considered a disease of life, and those aren't covered, compensation claims under the Georgia system. The other thing you're going to have for people participating in this program is employment law claims, and you're going to have a resource available. On the county side, you're going to have the helpline with Gerard and Davis. On the city side, you're going to have the attorneys at Ellerby Thompson. Employers have specific responsibilities under the Families First Coronavirus Response Act if you have an infected employee, in terms of compensating your employee, and that's going to cover some of the compensation that would come through the workers' compensation system, but I'm not going to get specifically into that right now because Doug Doer has a specific employment law presentation. Those are the only kind of claims you would potentially see from your employees, the basic employment law claims. And if you saw something where an employee tried to sue an employer under state law under a negligence type claim, the workers' compensation exclusive remedy bar would apply. The third plaintiff, and this gets more into where you should have some concern is people you do business with at your city. This is members of the public who come in for a meeting, customers who are coming in to set up utility service, people who rent facilities from the city, people whose kids participate in summer programs at the city, people who come to court, any of those kind of things. There are three categories of potential plaintiff that an owner occupier of land has to live up to the standard of care with in the tort context. The first is a business invitee who is owed the highest standard of care. The second is a social guest, and the third is a trespasser. Any of these people who are coming onto your city property to do business with you are going to be treated probably as a business invitee under Georgia law. And I've quoted the statute there that provides the standard of care, where an owner or occupier of land by express or implied invitation induces or leads another to come upon his premises for any lawful purpose, he's liable for damages to such persons for injuries caused by his failure to use exercise ordinary care in keeping the premises and approaches safe. So if you operate public facilities, you have to use ordinary care to make the premises safe for your business invitees. So what does that mean? What are we supposed to do? Well, the first line of defense is going to be some kind of face covering. Everything I've seen says that the best way to prevent the spread of the coronavirus is really two things. You've got the social distancing where you maintain at least 6 feet, but then you've got some kind of a face covering. And if it's like a surgical mask, an N95 mask, that will help prevent you from getting it. But most of us aren't going to have those available, and actually the public health authorities recommend that we not use those because we're taking those away from people in the healthcare field that really need them to do their jobs. But if you just wear a basic face covering, that's going to keep you from spraying the virus. If you've got it and you realize it or don't realize, it's going to keep you from spraying and help keep somebody else from getting it. I've seen a statistic that's like 75% reduction in the transmissibility of the disease simply by wearing masks. And I've taken a snapshot here from the CDC website. There's a lot of good literature on the CDC website about masks. And what we recommend is that at a minimum, cities and counties strongly encourage people to wear masks. If it's not clear completely that you can require masks, there's a difference in legal opinion on this. So you have to make a policy judgment. Would you rather risk, potential litigation if you require masks, if it turns out that you can't do that, or would you rather risk exposure to people if you don't require masks? It's a policy judgment that the decision makers are going to have to make. With respect to masks, if you have people that don't want to wear them, you've got to balance the interests that are involved. If somebody says, I don't want to wear a mask to come into, City Hall to come to a meeting, you're interfering with their First Amendment right to public participation and public assembly. If you interfere with a protected constitutional right, you have to meet the highest level of scrutiny, strict scrutiny, which requires that the measure be necessary to further a compelling interest. I would posit that in the context we're in right now, we've had public facilities in Georgia that have led to outbreaks of the COVID-19 virus. We had a courthouse down in Dougherty County where they had jurors in a jury assembly room. One person came in and it went through the courthouse. We had one judge get infected. We had another judge get it and die. And I think that demonstrates the compelling nature of the interest that cities and counties have to protect their employees and protect members of the public. And in this context, I believe a mask requirement would meet constitutional scrutiny. You also may get a challenge under the Americans with Disabilities Act. If someone can't wear a mask, for a medical reason, under Title II of the ADA, cities and county governments have certain responsibilities. What I would say is that what you've got to do is make a reasonable accommodation, which means you have to do something that's not an undue burden to your city or county. That would mean if someone needs to do business with the local government, maybe You arrange to meet them off site. You do it via telecommunication. You come up with some means to do that that allows for a reasonable accommodation of that interest. If people come into City Hall and you have to seek medical information, HIPAA is not going to be implicated because state and local government, or city and county governments rather, aren't HIPAA covered entities in most instances. So I want to lay that aside. You do risk the possibility of spreading private information, and this can lead to a state tort of invasion of privacy. And what's recommended is that local governments simply have a yes or no questionnaire when people come into their facilities. Will you wear a mask? Yes or no. If they won't, then you provide a telephone appeal immediately so that they can deal with this privately, and you don't risk spreading their private information if there's some medical reason that prevents them from wearing the mask. In terms of reasonable measures that can be taken to protect everyone, we've been inundated with all sorts of information. I looked yesterday and I had over 630 emails dealing with coronavirus since early March. And I know everybody's being inundated with information every day. I want to point you to some specific resources that you can use as go-tos to fall in line and take reasonable measures to protect people on your city and county properties. The first, of course, is the CDC. On the CDC website, there's all sorts of useful guidelines to deal with COVID-19. There's information about what to do if you have an employee exposure, if you have, exposure on your property. There's a lot of good information in the governor's executive orders. The executive order that's in place right now is very specific as to certain activities. It's true that, organizations can open up, but you can't have more than 10 people who are going to be, within 6 feet of each other. There's specific guidelines for certain activities. There's a lot of information there that's very useful. GMA and ACCG both have information on their website. There's all sorts of checklists that have been created to help cities and counties return to work and make a safe workplace for their employees and for members of the public. And finally, on the LGRMS website, there's a lot of useful information as well. What I would recommend, if you're ever in a lawsuit and you're having to have your behavior gauged by that reasonable person standard, you want to be falling within as many of these guidelines as you can so that you're not assailable from a tort standpoint. One question that we've gotten over the past few weeks as cities have tried to reopen and get things moving is recreational facilities. We have a number of cities that have municipal pools. We have municipalities that are near beaches. We have municipalities with parks. What we have recommended is if you ever charge for the use of these facilities, do not do it right now. If you don't charge for the use of a recreational facility, you're going to have protection under the Recreational Properties Act. I've quoted it here on this slide, but if you don't charge somebody to use a recreational property, you don't extend any assurance the premises are safe, you don't confer legal status of invitee or licensee, which I discussed, and you don't assume responsibility and incur liability for injury or property caused by acts or omissions of anybody. So the lesson there is don't charge people to use your recreational facilities.
Hey, James, I got a question from an attendee. It says, at our housing authority, we are not open for business yet, but our employees and anybody that comes into our building, we have a sign on the door saying cannot enter building without a mask. We have given out a couple. Is this okay?
In my opinion, go ahead, Dan.
No, go ahead.
In my opinion, it is. This is really the debate about what's going on with the masks. We've got these executive orders that say cities and counties can't do anything more restrictive or less restrictive than what the governor has put in that order. The dispute is what cities and counties can do on their own properties. And it's not clear that the executive order would reach in and tell a city or county, you can't require a mask on your own property. And my interpretation is that they apply generally to, the man on the street, the general population. But when it comes to properties that are owned by cities, counties, housing authorities, I believe they can take reasonable steps to protect people on those properties. And in my opinion, it would be permissible for a housing authority to require a mask with a caveat. And this is true with any of these public facilities. If you are going to require masks and you're going to not let members of the public come in, you're going to be dealing with everybody in the public, which means you got people who may not be able to afford masks, don't have access to masks. My strong recommendation would be that you have a supply of masks that you can at least make available. So yes, I believe you can require it, but if you require it, you need to provide it to people that don't have access to them.
And you would strongly encourage them to provide any type of PPE for employees, correct?
Absolutely. Absolutely. Any employees who are going to have to be dealing with the public, you should absolutely provide PPE so that you can protect your employees. You might not have a compensable workers' comp claim, but I believe you still have a moral obligation to protect your employees. And your employees, if they get it, they may spread it to other people. So I believe it's very smart that if you provide PPE to any of your employees who are going to be dealing with the general public, and this would be like public works employees, firefighters, policemen, if you have a municipal ambulance service or a county ambulance service, they certainly need to have PPE. So anybody that's going to have contact with the general public who could either be exposed or spread the COVID-19 virus, they should have PPE, yes.
Got another question, James. Back to the recreational facility slide. Did I hear that correctly, that the recommendation is not to allow tournaments at the moment due to charging for these services?
No, I just said for the use of the properties, I would not charge any participant.
So if they're charging for tournaments, they should not charge for tournaments at this point in time.
That is correct. Any charge they make is going to negate the protection of the Recreational Properties Act. It basically provides an immunity. And, I don't know about having a significant event like a tournament anyway. But if you're going to let people come onto the property for more casual use, they don't charge them. If you normally charge people to use the swimming pool to go to the park, don't do that. I think if you're going to do something as elaborate as have a tournament, I think you may need to really look at the protective measures. Along with the Recreational Properties Act, you need to make sure that they're doing social distancing, the measures are in place, so that you don't have something that could create a hot spot or end up on the news, like the stuff we saw over the weekend.
Here's a couple other questions. Can I deny anyone entrance if they do not comply with our self-screening or health questionnaire policy?
Let me reserve that and get through I'm going to get to that with my last two plaintiffs and talk about, and the answer is, I believe, yes, you can bar access, but I think you need to be careful with how you do that.
And last question, with CDC guidelines advising visitors not to use playgrounds, should the city open playgrounds?
The best recommendation I could make, the closest thing I've seen to a playground is, in the last executive order, there was specific information in there about summer camps. And I believe there's a lot of useful information there. I think you need to be really careful if you're going to have people out there. The kids need to socially distance. At some point we do have to get back to work, and unless the legislature, approves a bill that would provide immunity, there is the risk of, litigation. I would make sure anything I did, like reopening playgrounds, that I was in compliance with CDC guidelines or some objective authoritative guideline that I could point to if anyone did get infected. So if they said that, I could point back to that. I can't tell a city or county not to do that. I mean, at some point you do have to get back out there. We're not going to go on forever without having playgrounds, but as you do it, you really need to dot your I's and cross your T's as you make sure that the facilities are safe.
One last question, and I'll let you go on. Can we still charge for parking but use the facility free?
I haven't looked at the parking issue. This is sort of the way I would look at it. If it's a separate service of parking that you would normally pay, it's a lot that people would use to park in separate and apart from the use of the rec facility, I think that's okay. If it's not something that can be separated, if it's something that's normally tied together, I would not charge for parking, because I would not give a plaintiff a way to get around the Recreational Properties Act. But if it's a commercially available, parking situation that anybody can park in, whether they're using, rec facilities or not, I would think that would be a separate service the city's providing, separate and apart from the rec facility. I'm going to move on and talk about the last two plaintiffs. Plaintiff number 4 is the true believer, who wants to come in, participate, in community events. I've talked about this a little bit. You've got First Amendment concerns that are implicated. You don't really have so much of an equal protection issue here, because there's not really a protected classification, for people who want to wear masks and not wear masks. If you made white people, wear masks and black people not, or vice versa, then you would implicate a suspect classification. But there's not anything like that that's really going to come into play. You do have ADA public facility requirements. The tools for people that want to participate in public proceedings are, video conference meetings, reasonable accommodations, meeting people outside, doing business over the phone, using the uniform questionnaires that I've discussed already. The last plaintiff who I want to spend a little more time with is the person who wants to come in forcefully and not wear the mask. If you're going to require a mask, or if you're going to require social distancing, or whatever you're going to require, what do you do if you have the people that want to be, civilly disobedient? What do you do? This is a situation where your city or county might require face coverings, but somebody says, I'm not going to wear one. This is a scam. This whole COVID-19 thing is, just a big government conspiracy. Well, let's talk about the issues. One is if we're wrong and the government's if the local government's preempted, and you can't require that, it could be unlawful. If you arrest somebody, this happens in a lot of our false arrest cases. Somebody gets in a dust up with a cop, the person gets arrested, and then for whatever reason, the prosecutor drops the case. What if you go and try to make the person wear a mask, and it escalates quickly? The person ends up, on the ground getting pepper sprayed, asbeton, tased, all that. You've got people standing around with phones. You end up with it on the news. It looks bad. That can happen. What if the officer ends up in a physical altercation with somebody who doesn't have a mask on, and they turn out to be positive? Then you've got your officer exposed. The potential claims you could have in these situations are Fourth Amendment seizure claim for the arrest, First Amendment retaliatory arrest claim. I'm here trying to exercise my First Amendment right to get in that building and participate, and you're stopping me and you're arresting me for that. That's a retaliation claim. Malicious prosecution, false arrest. You put your hands on me, that's a battery. Those are the kind of claims you could deal with. And even if you take the person into custody and they end up in the jail, now you've got somebody in the jail who doesn't want to comply with any of this stuff, and they could expose the rest of your population. Then you've got a real problem on your hands. So what are the things that I recommend? You need to first make a determination how you're going to deal with this person. Are you going to stop them? Or if you're really going to require it, are you going to stop them? Or are you just going to let them come on in? Because if you're not going to stop them, you're not requiring it. You're strongly recommending it, and that's a policy decision that you've got to make as a local government. Weighing out the benefits and the risks. If you decide that you're going to arrest people and prosecute them, you need to go talk to the prosecutor first and make sure that they're on board. And my recommendation would be that you prosecute these people at the lowest level possible. And that means if you can go through the city court, go talk to your city court solicitor. If you go through a state court, talk to your state court solicitor. If you have to go through the superior court, go talk to the DA. But I can't tell you how many false arrest, Fourth Amendment cases I've had over the years that started when a DA was not interested in prosecuting a case. The DA may not be interested in doing this, especially if it produces negative public attention. And, we all have our opinions about DAs, but they're generally politicians. And if you can't count on them to see the prosecution, then, you may have stopped this person from coming in, but you may have gotten a $100,000 civil rights lawsuit out of it. So make sure your prosecutor's on board. Make sure that your entire encounter is on videotape. Now, cops wear these body cams and they're okay, but a lot of times they get distorted. If there's going to be a dust up and you have other people around, my preference would be for somebody on our side to pull a phone out and record it in a way that preserves the episode. So the videotape doesn't lie. If you're going to prosecute somebody, don't engage in a custodial arrest. Issue a citation. If you issue a citation and they're not arrested, you're not going to have a Fourth Amendment claim. The most you would have is a malicious prosecution claim. But you have to have a seizure to have a Fourth Amendment claim. So if you can do it, use a non-custodial arrest. Talk to your officers in advance and make sure they know how to de-escalate a situation and use the utmost professionalism. If the guy ends up on the ground and ends up tased and pepper sprayed and all the rest of it on videotape, you want your officer to be bulletproof. You want him to look really good, like he did everything possible so that didn't have to happen. Do not perform a custodial arrest unless that person puts his hands on the cop. The cop doesn't have to let the guy come in the city hall or in the city court or whatever. But if the person puts their hands on the officer, it's on. At that point, all bets are off. Anybody who touches a cop is going to get arrested. It's a custodial arrest. But once that happens, you need to make sure they're bonded out as quickly as possible. So the duration of the arrest encounter is as short as possible, and so that you don't leave that person in your jail population. If they're not a violent offender, you need to make sure and get them out of there. Anyway, those are my recommendations, and I'm going to hand it to Doug now so he can talk about the employment law issues.
Hold on, Doug. Here, I'm going to make you the presenter. It's all yours, Doug. I think you might want to turn your microphone on, Doug.
You're right, I probably do. Although some people actually enjoy me being silent, so that might be there's something you want to keep in mind. So, whoops, let me put the slide back up here. So I know we want to give Rachel and Greg as much time as possible here. So I'm going to cut my presentation a little bit shorter to make sure we get through everything. This is the slide that, as outside lawyers put up there that says you can't rely on anything that I tell you here today. In terms of what it is that you're doing in terms of bringing employees back, as James mentioned, I'm going to talk primarily about employee issues. even though we are, as local governments, are not covered by the Occupational Safety and Health Act and the Occupational Safety Health Administration, it's good to, since they're focused on workplace safety, it's good to take a look at some of their guidance as well. I know James already mentioned a number of sources there for you with the CDC, the ACCG, GMA websites, and all those sort of things. As an employee focus issue here, I like to look at the Occupational Safety and Health Administration website as well. It's largely consistent with the CDC, although there are some minor differences. But one of the things that talks about is you need to look at each job that people are going to have there with you to determine what the risk of exposure is, whether it's a low risk, high risk, medium risk, wherever it is, because that really governs the type of protective measures you're going to put into place. James mentioned here, right, although we've got the workers' comp bar, very helpful in terms of bringing preventing claims against us as local governments. In fact, aside, not only we have a moral issue here, we do need to take reasonable steps to protect our employees because they are a valuable asset. That's how it is that we are able to provide the services to the public that we do. So you need to look at those positions and you need to assess what the risk areas are. There are a number of engineering controls that can be put into place to provide protection. These engineering controls provide protections not only for the employees, but also for the visitors, members of the public who come in. Look at things like airflow changes. Can we route the air to flow in certain directions? Can we add in air filters, HEPA filters, or the like? Putting in physical barriers where we might not have had barriers before. Like if we had an open office plan, social distancing is one thing, but putting up barriers, whether it be plexiglass shields, these types of shields can come into place to protect our employees. And those shields would also not only protect our employees, but also protect members of the public who are interacting with them. So these are the types of engineering controls we can look at. Removing, common touch items to the extent you have waiting areas, maybe remove the number of chairs that are in the waiting areas. If you have break rooms, you remove the number of break rooms, tables, desks, all those types of things in order to increase the social distancing. Removing common touch items, and these things you can also find out in the governor's orders as well. In addition to that, we can look at what I call administrative controls, screening of employees, which I'm going to talk about in a little bit here, and about PPE. James mentioned this already in terms of the efficacy of certain types of masks and protections. Obviously, we would love to be able to hand out N95s to everyone and require them to be worn. They're not available. Many of the ones that are out there, there's some real serious questions as to whether they are in fact compliant, those types of things. But we can certainly begin to consider whether we require our employees to wear masks. James mentioned that there's certainly an open issue, or at least a debate, as it relates to whether we can require members of the public to wear masks as a condition of entry into our facilities. But in terms of what we can do for our employees, we certainly can require them to wear face masks of some types, whether it be a filtering face piece or a cloth mask or something along those lines as well, is something that we can require our employees to do. Now, there are certain limitations on that. There could be religious objections to that. There can be Americans with Disability Act, somebody's disabled, they might not be able to wear certain types of masks because their breathing issues or the like. These are things to keep in mind, requiring people who interact with the public to wear gloves, those types of things. So in terms of PPE, and remember, this is all part of our hazard analysis, looking at what a particular job might require to make the employee safer, to have it a safer environment for them. And I'll talk about in a few minutes why we want to make sure we're doing that in addition to the reasons I provided. We want to look at changes as to what we might do in terms of staffing, workflow, what services may or may not be provided at certain times of days, or what sequencing, those types of things, and what it is we do in terms of disinfection procedures and the like. Now, James mentioned here the Families First Coronavirus Response Act, and that was I know that a lot of material went out on this back in March and April. on this, and I'm not going to, in the few minutes that I have, I want to, again, leave as much time for Greg and Rachel as possible. I'm not going to go into great details about that, but one of the things I want to remind you of is that so these provisions here of emergency paid sick leave or expanded FMLA, you might not have worried about them so much in March and April because we were shutting down things, people being furloughed, people were not being told not to come into work and the like. And so although some of you dealt with some of these issues, and I know because I spoke to a number of people at that time, as did some of my other colleagues here at L.B. Thompson, and I know Gerard, the firm would have also as well. I raise this because these are still laws, and they're still out there, and they're going through the end of this year, and so you need to the extent that you don't recall what these laws require and those things, you need to refresh your recollection of those, and I'll touch on this again in a few moments. I also want to remind you that about the unemployment provisions, right? Individuals who are out and receiving any kind of unemployment compensation are employees. They're getting the $600 a week that goes to the end of July when that expires. And that they can have interim earnings up to $300 a week in order to continue receiving unemployment benefits before there's any reduction. And I'll talk about that in just a minute as well. As I mentioned before, one of the things we want to talk about is bringing employees back to work, and it's about screening. There's back in the early days before it was was declared to be a pandemic, the coronavirus was declared to be a pandemic by the World Health Organization and the CDC. There was some question about raising temperature, whether you could do temperature checks to people because of that fact that an elevated temperature, particularly at that time, was considered to be sort of almost like a surefire indicator that someone was down with COVID-19. Now, obviously, we know a lot more about it since then. But before it was declared to be a pandemic, remember, there was a significant limitation on ability to take people's temperatures or to really make any kind of inquiries about how they felt or their conditions. And that was because the Americans with Disabilities Act says, as you all should know, that you cannot make medical inquiries of current employees except those that are job related and consistent with business necessity. When it was declared to be a pandemic, however, that began to loosen some. It's not a wide open sort of thing. You still need to be very careful about what you do. So can you screen for temperature? Absolutely, you can do that. The EEOC, Equal Employment Opportunity Commission, has come out and has said as much. So we can issue temperature checks for people. Do it every day when somebody comes in. Now remember, though, who's going to take that temperature? Does it have to be particularly trained? No, they don't need to be a nurse or something along those lines, but they certainly need to know how to use the equipment that's going to be taking the individual's temperature. Hey, and does that sound like perhaps a risky job to be taking somebody's temperature? The answer to that is yes. So think about what type of protections need to be in place for that. Maybe that person needs to have other kinds of protections in place. Maybe the wind, there needs to be volume of air coming from behind them and the direction of other and the direction of the people they're checking over from behind and forward, whatever it might be. Certainly more than maybe just a face mask in terms of that, so that they are protected from taking that. Maybe there's a shield that they reach around, whatever it might well be, keep that in mind. Likewise, we can screen employees for symptoms of COVID-19, but it must be COVID-19 specific. Don't ask general questions like, hey, how are you feeling today? Any aches and pains, those types of things. You want to be very clear that you're focused on what the COVID-19 is. Temperature, cough, shortness of breath, difficulty of breathing, sudden loss or recent loss of smell or taste, or any of those factors that are on the CDC webpage. Check for those frequently to make sure it comes into play. If you keep the information that regarding these questionnaires or the temperatures, which I do not recommend, but if you do, remember those are medical records and they need to be kept confidential. When you're screening employees for symptoms, don't do it in an open environment where other people can hear the responses to this. It needs to be kept confidential. You might have them fill out a questionnaire and turn in a questionnaire. Then you can either destroy the questionnaire or keep it in a medical file, whatever it needs to be, so that you ensure that it is kept confidential. All right. I mentioned antibody screening on here. That was trendy for a while. That's most definitely a medical examination. I don't require this. I don't recommend that you do this at that time. What about the time that's spent while these employees are going through this evaluation? Yes, that should be treated as work time when you do that. If somebody refuses to go to the screening or doesn't pass, then you can go ahead and refuse them entry. And then the last two slides here real quick that I want to get through. Another problem that a number of employers are experiencing is what if employees do not want to come back to work? There are certainly some issues there. You need to understand why it is the employee doesn't want to come back to work. Some of those reasons may be disqualifying for unemployment. That's important to know. But employees also have rights as well. I mentioned before expanded FMLA, emergency paid sick leave. Those are things that you need to keep in mind as to whether your employees will qualify for that. So watch out for that and be sensitive to that. If someone says, I can't come into work because I'm taking care of my children, that might be a request for leave under expanded FMLA. So you need to make those proper inquiries into that. So other people, you might have an ADA accommodation issue. If I have asthma as an example, or some other respiratory disease, right? And I'm at higher risk for that, you may need to consider whether an additional period of leave is necessary or some other job functions in there. You want to make sure employees know what the safety measures are that are implemented, because although a generalized fear about getting sick is not, it will be disqualifying for purposes of unemployment. If you are not providing a safe workplace, you're not taking the steps to protect employees, then that fear is no longer a generalized fear. It's no longer unreasonable. It may qualify them for unemployment. Real quick, last slide. I wanted to let you know there's some new guidance out from the Georgia Department of Labor. If you haven't made yourself aware of it, I haven't looked at their website, do so, about what to do now as we're bringing people back to work. If you're keeping people out on furlough, you continue to file for them on their behalf for partial unemployment. If you're bringing them back, even if they're working part-time, you continue filing, reporting the reduced hours in there. If employees, which I'm hearing some local governments are doing, in addition to private employers, are just having permanent layoffs, you need to convert them to laid off. You do that electronically. There's instructions on how to do that. Again, go to the website, go to the employer portal and check that out. If some employee just say, I'm not coming back to work because of my kid, whatever it might well be, and they're not going to qualify for the expanded FMLA, then you need to stop filing on their behalf. And there's a click on there, and you go and report. It's very it sounds like a fraud issue. But what you do is you're simply sending a signal in to the department. When you click on that, you're sending a signal in to the Department of Labor that says, hey, stop just paying these people automatically. We need to determine whether their refusal to come into work still qualifies them for unemployment. And if you do a severance retirement package and the same thing, you don't actually report them as fraud. You issue a DOL 800 and advise them to report their claims. So with that, I've left a few minutes. I'm sorry I went over a little bit there, Dan, but
Doug,
Greg and Rachel.
You did fantastic. Thank you so much. A couple questions, and you kind of answered these, but I want to make sure you're clear. If an employee says they are afraid to return to work, what are the options? So, they don't really give any reason. They said, I think they just are saying, I don't want to come to work because I think I might get COVID-19.
If an employee just flat out says, I'm not going to come back to work because I have a generalized concern that I have COVID-19, and you've offered them work to do and they cannot work remotely, you should not continue to file for them for unemployment because they're no longer eligible for unemployment under those circumstances if it's a generalized fear. I would make, as I've mentioned here before, I would make some more inquiries to see if I can get a better understanding of what that is. Maybe it would be not disqualifying under the circumstances. They might be eligible for emergency paid sick leave or whatever else. They certainly, if they have accrued leave benefits to them, they can use those accrued leave benefits. Once they run out, then that's it. Just like you would for anybody else, you could move them into an unpaid leave status if you wanted to, but stop filing for unemployment.
Okay, very good. Here's a question. Does age only with no other medical issues qualify for ADA accommodations?
What a great question. And the answer to that would be um, nobody. There's no real good answer to that yet. At the moment, I would say the answer of age alone would not qualify you for a disability, because that doesn't meet the definition of what it means to be disabled. You know, impaired as into a major life activity. I can see a very creative argument being made that under the circumstances, given the nature of this particular disease, along with the combination of a reduced immune of responsibility, does rise to the level of disability. But I don't, that's going to come further down the line. I don't see that as a clear claim of litigation at this point in time, because frankly, getting older, I no longer see being 65 as being old, right? But the reality of it is, even as you're getting older, within the general population, your immune response decreases anyway. So I just don't see that as a valid claim.
So here's the last one, and then we'll move on. Somebody had asked about, and you'd covered this, about taking temperatures, what personal and protective equipment was required. And you kind of said it really depends on the situation. Do you have just a general requirement that you would say for taking temperatures?
Well, I mean, I'd first of all make sure that you tell employees not to come in if they have a fever, if they feel sick, or any of those circumstances, so that when the person who's taking that temperature has at least, there's no, if someone is clearly sick before you're taking the temperature, then obviously you shouldn't take the temperature. They should go home, right? Really, if I'm the person who's taking the temperature, I'm taking the temperature of somebody who is not currently suspected of having COVID-19. So therefore, the degree of protection that's required is lower. I don't think you have to require an N95 for that. If I knew that the person was sick or potentially sick, then I would require an N95, and good luck finding one. So, I would make everybody wear a mask anyway, at a minimum.
Yeah, a mask or barrier, do hygiene, cleaning surfaces, cleaning areas, making sure people. So I think as long as you're taking even social distancing, I think you're in probably pretty good shape. So we can work on that question a little bit more when we get to cities. Thank you so much, James and Doug. Let's. I'm going to go to Greg and let him talk a little bit about what they're doing within the city of Griffin. So hold on one second.
Am I on?
You are on, and I am trying to get my screen here.
Right.
So can you see my?
Yes.
Okay.
All right.
And
Thanks,
I'm gonna
Dan.
start.
Hello, everybody. I'm Greg Poole, the risk manager for the city of Griffin. And I want to talk to you a little bit about what we're doing here today. Give you a little bit of background. At the end of March, we began our staggered rotating work day and schedules. And as of May the 11th, all city workers reported back to work normal schedules. And what you're seeing here, and we'll be seeing, are pictures that were taken of our workstations and things that we're doing that put into place. But as I said, we returned Monday morning, May 11. All city workers reported. So we're now well into our third week of all working together. And as you can see here, there's a workstation in customer service with the physical barriers that Doug mentioned. We have several of those up. We have some plexiglass in customer service. Here's the EMT taking a temperature check. Now, we have this only at one entrance of our building, which is our rear entrance. We closed our front entrance, and our rear entrance is open to the public. And that's where most everyone, not many employees enter there, but all public enters there, and their temperatures are checked as they enter. And these are some social media posters that were put out there. Police and fire, solid waste. And that's hard to see there, but there's a plexiglass there in front of that customer service rep, along with a physical barrier.
Greg, are you requiring people public to wear masks while they enter the building?
We are not. We're asking that only one family member enter. As with employees, it is at their discretion if they want to wear masks. I talked to the customer service manager this morning, and they've even done a little bit of babysitting outside. As a mom may have not been able to leave the child at home, but it's come in. So we've had an instance or two where an employee will go out with a mask and will stand there with the child as the parent is inside conducting business for the city of Griffin. That's our security officer there. And this is the sign at our front entrance asking everyone to go to the rear entrance. One of our customer service reps there with plexiglass and the barrier. We have signs posted throughout the building asking the public, adhere to the social distancing. We have sanitation and hand washing stations around. Our employees are wiping down surfaces, trying to practice social distancing. And we're not having a lot of meetings. And when we are, they are in rooms where, you can practice social distancing. You'll see our courtroom, I believe, in a few minutes, where the chairs are spread out.
I guess I didn't have that picture.
Okay, all right. We have trustees that are going through wiping surfaces. Go ahead, Dan.
So you don't have, right now, you're not requiring employees to wear masks in the building, or are you?
We are not requiring
So,
them.
okay, very good, and not requiring public to do that. Anybody have any questions for the city of Griffin? Thank you so much, Greg. Rachel from Ackworth, do you want to talk about what you're doing?
So we're pretty much doing the same thing as the city of Griffin. We are in our second week back. We came back on the 18th. Prior to that, we were all on an alternating work schedule, so we were still operating. We just wasn't open to the public, but everybody was still working every other day. So we pretty much gave everybody a little over 2 weeks notice that we were all returning on the 18th for anyone who needed to make arrangements after being home with their family members. Prior to that, we have signage that we've put in place outside the building, inside the building, signage on the floor for 6 feet social distancing. We've provided everybody with face masks, all departments. As far as our PD, our power, our public works, our sanitation, those employees in our parks, they are required to wear a mask if they are in a vehicle with more than one person. So if it's 2 in a vehicle or more, they are required by their department head to wear masks. As far as us in City Hall, everybody has the tools. Everybody has masks, gloves. We've got sanitizing stations throughout all facilities. We've got wipes. Employees are recommended to wear masks, but it's not required. It's recommended if they're doing face-to-face with someone that, they wear a mask to protect themselves and others. Any open area spaces, such as like our front desk and our customer service, our customer service has a glass up already. So anywhere that needed a glass barrier, it's been put up at this point for everybody to utilize. Gloves are provided. We're doing temperature checks. It's done by every department. Supervisors are the ones doing it. There's a log that they'll just check off with their employees' names to say, they were within range, nothing was wrong, and they'll ask them a couple of questions every morning. All employees knows who to go to in their department who's actually handling those. Our courts have started operating. I want to say this is their second week. We had our first live council meeting face-to-face last week. Everything is being done, social distancing, move chairs out. Chairs are 6 feet apart. Council sitting 6 feet apart. Everything is being streamed live on YouTube. So anybody who wants to look at the council meeting can watch it on YouTube. Same with our courts. It's being shown live on YouTube. Only one person is allowed in courts. They're taking temperatures. They're following whatever the state guidelines are for courts. And that has been running smoothly thus far.
Very good. Very good. Let's and we'll open it up for questions in just a little bit, but let's Meg, are you out there? Do you want to?
Yeah, I am here. We're doing pretty much the same thing as others. We have opened City Hall in stages. Initially, only by appointment, and had to meet in a specific room with social distancing, and that room was immediately cleaned as soon as people left. Because they had to escort people into the building. We are now open to allow people within the hallways, but not into individual offices. We are not taking temperatures, and masks are optional. We do have a temperature, one of those thermal devices for the courtroom and for council. We have been having council meetings have been live, but social distancing with several council members calling in, and of course they're streamed. They've been streamed for a while. I guess we're back at work. We started Tuesday was our first day back at work, where everybody is here. So we're still not completely open to the public. That'll be June 15th. So it's a very phased process for us, and we're still not completely there yet. So other than that, we're pretty much, I think, doing the same thing everybody else is doing. We've been very lucky in terms of how our employees have not been exposed. We've had a number of people exposed, but we have only had one positive employee through this whole process. So we've been very lucky in that sense. But I like some of the ideas that James and Doug had. So those I'll be talking to my city manager about those too.
And if you want, we've talked to a bunch of different members and have a wide range of plans, so we can share those with you, from members that are, again, screening every employee coming in, asking questions, taking temperatures on a daily basis, requiring people to wear masks when they're in any common areas. So if they're working in an area where multiple people are and they can't social distance, they're required to wear a mask. If they're in a meeting, if they're meeting one-on-one, then they're required to wear a mask. If they're in their own office and they close the door, then they're not required to wear a mask. And they have cleaning schedules where they're cleaning surfaces on a regular basis. Any common areas, they shut down any type of food going in there. The public basically having the same requirements where they're requiring masks for the public, and then if they don't want to wear or follow the recommendations, they have an alternative procedure for accessing that particular building. So if you are interested in any of those plans, let me know and I can provide those. And again, Greg and Rachel and Meg, I'd really like to thank you for your participation. I'm sure you'd be willing to answer any questions if you have any. And again, what I would like to do at the end of this, we got a few more minutes, or I'll let it go a few more minutes, and I'm just going to ask these questions that are still outstanding. What about the public renting out of facilities for their personal events like birthday parties and such? So I think that goes to you, James.
That makes me cringe. We've gotten questions from some of our members, particularly back when this thing was heating up, whether they should suspend that. I'd be really careful. I think this is going to fall under the governor's executive order, where, when there are going to be places that people are going to come together, and a gathering is defined as more than 10 people. And if you're going to have more than 10 people within 6 feet of each other, you can't do that under the current executive order, which expires in a couple of days, but I anticipate there'll be another executive order after that. And then if you're going to make your public facilities available, all that business about invitees is going to apply. my personal opinion is it's probably too early to be renting out facilities like that for people to be having events where you can't really police it. And if you do it, you know, then the question is, cities have an obligation to enforce the governor's executive order. I probably would recommend against it right now, honestly.
Kind of a question similar. Can a housing authority say no to renting our 2 community buildings even free? I would assume the same answer.
Yes.
Okay. Here's another question. If you are a immunosuppressed, does that qualify as ADA accommodation?
Well, I don't know what you mean by ADA accommodation, but in terms of whether that's somebody who might be disabled by that, then I would say the answer to that is yes. It's likely to be, that is likely to be held to be a disability that you may then need to accommodate.
Okay. Can a municipality be considered negligent or be held to legislation if staff, specifically our solid waste collection teams, verbally addresses fears of performing clarity tasks? Oh, daily tasks.
I'm not sure if that's an employment question because it's got a First Amendment employment issue, but then, Doug, do you want
to? Well, I mean, you cannot retaliate against an individual for raising a First Amendment, First Amendment right aspect of it. Employees don't have a right to strike, but they certainly have a right to raise their concerns and to speak out on an issue of public concern. Now, whether this is a public concern or a private concern, I'm not really sure I understand the question very well, and I'd want to see the question there.
Yeah, I think the question is basically, can we be considered negligent if somebody's complaining and we force them to continue to work? And again, I think
that would be the work. It depends, but I would be more of I would think that more of a workers' compensation bar issue, and there I would not be worried. And well, I'm always worried, right? I wouldn't be a lawyer if I wasn't worried. But I would say that would certainly be, I would not be too concerned about that from a liability standpoint, from the purposes of the workers' compensation bar, assuming that is a city or an appropriate a county employee of that through the BOC or whatnot, then that would be a workers' compensation bar in that regard. So I would not be too alarmed. I would look at it more from a First Amendment, although that may be more of a private interest, and then just sort of the public relations angle.
That was where I was headed under the Garcetti case. If it's something of a public concern, then that's going to be protected. If it's something that has to do with their job, that's not protected. And my advice would be to call the helpline and talk to the guys.
Yeah, I call the helpline, and even call LGRMS. If you have a employee that has a safety and health concern, we can help you put in a control plan. And again, we can tell you if your control plan is adequate or not. So let us know, and that's something we can assist with. But also call the helpline, and we can assist with that also. What cities were Rachel and Meg? Again, Ackworth, the city of Ackworth, and the city of Noonan, respectively. Rachel from Ackworth, Meg from Noonan. Good questions. Will we receive a copy of the recording? Yes, I will send a copy of the recording and the slides to every person that registered for this, and you're free to distribute that to whoever you'd like to. Is anyone taking temperatures of public as they enter a facility, city facility? That's a good question. Anybody taking temperatures out there of the public when they're entering a facility?
Yes, we are, Dan.
Okay. How's that going?
It's going rather well. We've been doing it for many weeks, and there have been citizens that have been turned away. I don't think there have been many, but there have been several. One in particular who came up, a lady came up and said that she had been tested positive, but it had been 30 days. There have been others with fevers that have been turned away, but again, not in great numbers. But everybody is complying because it's explained it's for their safety and the safety of our employees. So when they have to leave, they so far have understood.
Very good. Well, that's the last question. I would highly recommend, again, if you have specific employment questions, call the helpline. If you have safety and health questions, call us. You have liability questions, call James. We're all out here to help and provide you. You know, the interesting thing is we don't, we don't have all the answers. This is kind of a moving target as we speak, and we'll continue to evolve and continue to get better at being answering these questions. But in the interim, please let us know if you have any questions. We will be happy to assist you in whatever way we can. So thank you for that. I do have another question here. When taking temperatures of staff or the public, should temperatures be saved or discarded?
I would recommend discard.
I would recommend not even documenting them. Is that correct?
Yeah. I mean, you might, you know, for a staff member, you might record that their temperature was elevated and that don't record the actual amount, and that they were then sent for an evaluation or told to go get an evaluation. But I wouldn't record a temperature. There's too much there at risk. Most of the devices, the handheld devices you get, you don't know how accurate it is. Plus, you don't want to create a medical record when you don't need to.
Very good. Very good. Thank you so very much. I really appreciate it. Again, I will be sending out the presentations and the recording later on today, early tomorrow morning, or maybe Friday morning. In the interim, if you have any questions, let me know and I'll forward those to the respective people. Thank you so very much to our panelists. Great job. Pat yourselves on the back. Thank you to all the people that participated. Really appreciate it, and we will talk later.
All right.